Good afternoon. In the interest of time and in light of the fact that we have an outstanding panel, I'll propose that we'll begin. I realize it is post-lunch, so my goal is to really have a conversation between our panelists and with all of you, because I know we have an incredibly knowledgeable audience as well as incredible panelists up here. So this is the topic for our panel, second looks in the courtroom. So this in many ways kind of opens up a conversation beyond the initial stage of sentencing. On the other hand, it seems to restrict the conversation to courtroom and second looks. So I felt like the authors of the title were channeling Judge Frankel. After all, he critiqued the Parole Commission so substantially that it seems he critiqued it essentially, or he essentially critiqued parole out of the federal system. Now, however, we have some second look back, which the federal law has now expanded, but this time done in the courtroom by judges and with standards and reasoning. So presumably this all responds to his challenge of lawlessness and cutting sentences, cutting the disparity in sentences. So one of the questions will be whether this is something Judge Frankel would support, and if he could support it, should we expand, should we think about this differently? Now, we could not wish for a better panel in light of the incredible mix of experience. So we have two panelists who actually have practiced pre-guidelines and post-guidelines, and both mandatory guidelines and advisory guidelines. We have two people with incredible experience on the defense side, white collar and other types of defendants. We have a well-known former federal judge, prosecutor, and a defense lawyer. And we have someone who is heavily engaged as a change agent in sentencing advocacy and personally experienced the federal prison system and also has family who've done that. So with that kind of expertise, I really want to run this as a round table. So the first question ties in with some of the issues that we heard earlier in the discussion of purposes. Now, what should be the purpose of second look sentencing? Or maybe better, what should be the purposes? What should animate this second look? And therefore, what will be the structures that develop out of that second look? We want to start to my right. Norm, if you want to get started on this conversation.
Sure. Yeah, thanks very much, and good afternoon, everybody. I think it's important to understand, as the second look movement gains some momentum, what it's all about. It's a palliative. It's to ameliorate the draconian structure in which we operate. And let's not lose sight of the fact that while we're talking a lot about the federal system today, the overwhelming majority of this tyranny is taking place in the state and local courts, and it is, as far as I'm concerned, the purpose of second look is a temporary measure until we figure out how to deal with the complete shift of the power to the prosecutors, the interplay of mandatory minimums, unbridled charging discretion, which has given rise to what we call the trial penalty, coercive plea practices, which I understand just this past weekend, the ABA's criminal justice section has come out with an amazing report, which they'll take to the House of Delegates, that finally calls out and seeks to reverse the ABA's unilateral blessing of plea bargaining. As far as I'm concerned, the purpose of second look sentencing is a stopgap measure to restore some humanity to an inhumane, coercive system in which, by and large, the most draconian sentences are imposed on the least culpable.
Well, okay. I don't disagree at all. Let me back up. I speak in my personal capacities. I do sit on the Sentencing Commission, but in no sense do the views I'm expressing here are they anything but my own. Let me say two things. One is just a more clinical way of saying what Norman just said, which is, and there's no respect in which this was anticipated by Marvin Frankel or the others who were the engines of the move to determinate sentencing, the regime we now have in the federal system. And I'm a Fed. To the extent I have any expertise, it's in the federal system. And to put a fine point on it, one important need for some form of second look is just a check on prosecutorial discretion. The movement to a determinate regime in a way that was not at all anticipated, just relatively empowered prosecutors. And because discretion goes somewhere, when there's discretion in the system, and there's still discretion in the system, we don't have a system in which for every bank robbery there's a prescribed 15-year sentence. There's discretion. Some remained in the judicial branch. We'll put that aside for a second. But prosecutors were empowered, not just by the diminution in the judicial discretion with the implementation of the guidelines, but with the enactment of mandatory minimums. And the truth is, prosecutors have not used their power in ways that have eliminated the need for a check on it, right? Prosecutors use their power. They don't cull the worst of the worst drug dealers and then file those 851 enhancements against them. They don't take 924C, that draconian look like a recidivism enhancement. They didn't cull the worst of the firearms offenders and use those bone-crushing stacked 924Cs against them. Rather, and this makes sense, and I was a prosecutor once, I did this, they used those tools Congress gave them to make their job easier, to induce guilty pleas. And it doesn't work to induce a guilty plea if you don't punish those. This is the trial penalty dimension to what Norman just mentioned. It doesn't work to induce a guilty plea unless you punish those who refuse to plead guilty. So there's a direct connection between the dramatic diminution in the percentage of trials in the system and the way prosecutors use their powers. So in one very important respect, there's a need. I mean, we have three branches. We believe in checks and balances. There needs to be an after-the-fact check on prosecutorial discretion, which can and is used to cram excessive sentences down the throats of sentencing judges. The second thing I'll say, in addition to what Norman mentioned, is even if one were to kind of cure that problem, good luck, we're working on it, but these are real people on the end of real sentences, and anybody who thinks that someone who commits a crime that, let's assume for argument's sake, is deserving of a lengthy sentence at the time sentence is imposed, anybody who thinks that person can't change in a way that makes them commendable or even admirable just doesn't know what people are capable of. And so separate and apart from imprudent uses of prosecutorial discretion is just the reality that people grow up and times change, thoughts about crime and punishment change, people change, incarceration rates change. There's a need, in the interest of certainty in sentencing, the parole commission was abolished, but it doesn't alter the need in just human terms to look back, to look at people, take a second look. You pick it. 10 years into a long sentence or 15 years, whether it's before a judge or some other decision-making agency. It makes no sense in human terms to forget that person, however just you might think the imposed sentence was, to forget them for decades, for the rest of their life. It's just, in human terms, to me, indefensible.
Yeah, well, I want to first and foremost put a full disclaimer. Allergy season is at its all-time peak. So even if I sneeze, cough, I do not have COVID. I tested myself prior to coming here. Yeah, we can get closer, a little bit more intimate. But look, I appreciate the thoughts and opinion from both the judge and Norm. When we think about what second look sentencing is supposed to be, it's a process that is supposed to allow for review and potential modification of a previously imposed sentence of that individual. And there are things that change in a person's life. The person that you were 10 years ago should not be the person that you are today. When I was sentenced in 2020, at the age of approximately 22, 23 years old, my brain hadn't even fully developed. There were mitigating factors that were not taken under consideration at the time of my sentencing. One of which happens to be the fact that both of my parents were incarcerated when I was 5 years old on the federal level. Another sentencing consideration that was not taken into account was the fact that I myself was shot at the age of 14 years old. There are dynamic factors that don't necessarily show up in a pre-sentence report. And so I really, just plus what the judge said about the value of second look in sentencing being, in effect, what it means is that you are extending grace to an individual. You're extending grace through the criminal legal system to an individual to give that person the opportunity to grow, to give that opportunity to that individual the opportunity to represent back before the court as a different person. What have you done since you've been incarcerated? What other factors that may not have been considered at the time of the initial sentencing that the court should probably take a look at currently? Those are the things that should be, that may not necessarily show up in the stat sheets when we are considering second look sentencing, but those are the things that actually should be part and parcel of the conversation. The last thing is, I personally believe that there are no throwaway people. We live in a society, literally, if I took one of these plastic cups and I walked over and I tossed it in the garbage can, somebody would probably tackle me because I didn't discard it appropriately. But when you think about human potential that is diminished through disproportionate sentencing and excessive prosecution, how deliberate and how intentional are we about ensuring that that human potential isn't just discarded, isn't just thrown away, isn't just forgotten about, isn't just languishing? And so I believe in a notion like my grandmama taught me, grace will go to the highest of heights and the lowest of lows. I do believe that there are people who have committed very egregious offenses. That's without question. I got some cousins that I don't want to bump into in a dark alley. But the fact of the matter is that when you think about human potential and you think about grace, grace is supposed to be in operation in every facet of life that includes our criminal legal system. And I think that second look sentencing should be, in effect, grace in operation. If I was going to do the Puff Daddy remix to it, that's what I would be calling it.
It's tough to follow all of that and to say something new. For me, much of what I think ought to animate second look sentencing regimes are exactly the points Lewis is making in a more compelling way, given the experiences you've had. But just to add some objective ideas, number one, we have a prison population that's too large. It's expensive. the Bureau of Prisons can't adequately care for the people they have in their care. The state systems are often even worse. We know that long sentences don't actually deter crime more than shorter sentences. We know people age out of criminality, by the age of 50, call it, having exceeded 50. I feel even more strongly about that one. So the notion of being able to take, a second look at judgments that were made when someone was often in their 20s or even early 30s, and take a look at that again when they're at an age when we can all agree they're much less likely to recidivate, when all of the realistic, appropriate purposes of sentencing have often already been met, seems like, the question ought to be, why wouldn't you do that? And we're not just talking about grace for the individual, but it's a chance to reunite families and strengthen communities. And in the long run, I firmly believe improve public safety by doing those things, by bringing families back together. You think about the children of folks who are incarcerated for, a decade or more, getting a parent home. That has unbelievably important positive impact on the likelihood of additional crime in neighborhoods and communities. So to my mind, all of those reasons make a lot of sense.
So I think we've all heard a multitude of purposes here, from basically fixing excessive sentences and prosecutorial excesses to, on the other hand, kind of the grace component, the rewarding personal change and rehabilitation, and maybe some more instrumental ones about helping us save cost of incarceration, us as a society, saving cost of incarceration, and also fixing other potential problems like helping communities. So honestly, this raises for me the structural question. What we're doing right now with second look in the judiciary, in kind of a, I'd say, somewhat traditional system, though it's on the back end, is that the way we should be handling all of these situations? Or is there a reason to think about bringing parole back or having different mechanisms to solve these different issues? I'll start on this side this time.
My own instinct is that, judges are the right place. Judges in courtrooms with hearings are the right place to do resentencings, assuming a few structural components. One is a right to counsel, I think realistically is required, and including to ensure you don't exacerbate disparities in sentencing, on the front end. I think having objective indicia, obviously in the compassionate release context, we have some of that. If you think about it in the context of proposed state second look statutes, the idea could be that you could have a set of criteria that judges ought to be considering. I personally think that it ought to be available to everyone regardless of the underlying offense that was committed, and there should be some period of time that has to be served before you would get the second look. So I know that ALI has a model penal code that came out, and I believe they used a 10-year minimum term of imprisonment before you'd get the second look, which as a practical matter means that you really would have had, because it wouldn't account for good time credit. So effectively, you'd have to have a sentence of really 15 years or more to get the second look. So it's actually really focused on folks who are getting very long sentences. But to me, I would keep it in the court system with judges, with a right to appeal, with counsel. For me, those structural components would be critical to ensure fairness.
For me, I think that it should be a combination of both. And I tread very lightly, having done work around supervision, understanding that, yes, there are approximately 2 million people, depending on what day you check Vera's stats. There are approximately 2 million people who are incarcerated, but you got approximately 4.5 million people who are under supervision. And those individuals are being returned back into custody, not for committing new crimes, for technical violations. So I err on a side of caution in terms of making sure that we're not creating another problem as a result of making sure that people get free. But I do think that it should be a combination of bringing back parole on the federal level, even though the federal level represents about 10% of our entire incarceration population, and also putting that back in judges' discretions. So for instance, I'm from Connecticut. If you want a sentence modification, the prosecuting attorney has to sign off on your sentence modification before the judge will even take a look at it. And so the same person who actually prosecuted my case is going to give me a yay or a nay. Most times it's going to be a nay on if whether or not there's going to be a second look in my situation. So I do think that judges definitely need to have more authority in being able to determine what other factors that may be taken into judicial consideration for that individual to be released, and or just to have his case, have his or her case, I should say, back before the court.
I certainly don't claim to have answers to these questions. One thing I find helpful is to look at what the problem was that led to a system that many people, including myself, think is unsatisfactory. And the problem was the kind of opaque nature of the Parole Commission's role in sentence lengths. And, there's a way to ameliorate that problem without eliminating all second looks. You can make it more transparent, whether that's with an agency like a parole commission and some transparency and explanation requirements imposed upon it, or a judicial remedy. You can't ignore these principles that, we deem sometimes more sacred than they really ought to be. Finality, we have a felt interest in finality. Whatever you do has to be administrable. So if it were to be, and I actually think finality, just to not hide my own light under a bushel, is way overrated. And it's especially overrated, a system that was supposed to usher in uniformity, transparency, and certainty, did all of those things to a degree, but for reasons that were discussed this morning, and Len Bias's death had something to do with it, many other reasons, the new system was characterized more by severity than by any of those other things, like orders of magnitude more characterized by severity, increased severity. So there was no reason to expect that necessarily at the time. So a system that took away the second look, unaware of the fact that it would be characterized by extreme additional severity, produced this problem. So yes, there ought to be a solution, one that's administrable. I'm not sure I would be sensitive in my own, speaking for myself, sensitive to arguments that if you can go back before your sentencing judge 2-3 years later, then we'd have to think about it, administrability. And maybe the answer to that is not, well, forget it, but resource allocation. I've been litigating a lot of these, a lot of cases in the wake of First Step, and so frequently I heard prosecutors say to judges, as though it were a reason for relief not to be available, if you grant this relief, I've got 15 other of these motions on my desk. And I know the prosecutors think that's a good, legit argument, but one legit answer would be, well, get another job if you don't like having to respond to these motions. Or tell DOJ, which has a very important say in the appropriations process, get more money. Like, there's no such thing as too much justice. And I've learned that there are places in the country where there is such a thing as too much justice. So, there are important kind of bedrock principles that are in tension with one another, administrability, finality, that need to be reconciled. My punchline is this is the kind of conversation that people in the system and policymakers in the system need to have, because the one thing we've acquired a consensus around is we do have a over-incarceration problem, and we have a need to decarcerate. And I think most people agree with that. So these are the kinds of things, remediation ideas that we ought to be talking about.
Well, Judge Gleason, you started your remarks by saying you weren't going to pretend to have the answers, but you do, as always, have the answers. And I'll start my remarks by saying I will pretend to have the answers. Finality in sentencing is the most pernicious concept I have ever heard of. And I come to this from the perspective of somebody who was fortunate to be part of the founding of what we called Clemency Project 2014, which was in response to the Obama administration's clemency initiative. A number of groups got together to provide pro bono, to recruit thousands of lawyers to provide pro bono representation. And one of the things that we learned in going through those cases, which to begin with had to be nonviolent, was the incredible number of people who, with no hope, with no reason to expect that they would ever come home again, had impeccable records. Over 300 of the people that came through our program, which resulted in 894 of the commutations, were light people serving life sentences, and many of them had never had a violation in prison. Now, how many of us can say that about how we live our own lives, that we've never had a violation? I have one guy who in 30 years had one violation for having illegal chicken in his cell. So, you know, the idea of finality when you give out these kinds of sentences is absurd and inhuman, and we should be embarrassed to even talk about it. So I agree with you on that point, Judge Gleason. Structurally, I personally believe I'm more comfortable with judges having the responsibility for this, because I have seen what happens with parole commissions. In New York State, we went years, right, without anybody ever getting released on a parole application, or one in 1,000. I mean, it becomes so politicized. I agree with Sean. It should be available to all people, regardless of the crime. Look, the most serious crime is homicide, and if you've ever dealt with people who are charged with homicide, you know that may be the least likely person to recidivate, and the circumstances may be the most sympathetic. The fine line between an incident which is self-defense and homicide is too subtle to say we're going to write this person off simply because of the nature of the crime. And finally, with regard to this idea of a threshold amount of time, I'm well aware of what the ALI has recommended. I know a number of the proposals are out there. My own belief is that the threshold should depend upon the length of the sentence. It doesn't make any sense to say it needs to be at least 10 years for somebody who got 8 years, who was offered 1 year if they had taken a plea before trial. That person should be able to get considered long before they've served their entire sentence. So we've got to have flexibility with this, but we shouldn't be excluding anybody.
Let me ask one last round of questions, which I think follows perfectly on Norm's comment, because I'd been wondering about a threshold and questions of unfairness on part of the people who don't quite make the threshold if you set an absolute numerical number. So the broad question that I have is, we've seen what happened to Judge Frankel's certainly well-placed and well-meaning recommendations. You can blame him for everything that happened afterwards, or at least for some of the things that happened afterwards in terms of punitiveness and rise of imprisonment. So I think, mindful of that, we need to think about possible ramifications of not the current version, I'd say, of Second Look, but the expansion of Second Look. what about disparity? How can unwarranted disparity? I want to be very clear here, because disparity can obviously be appropriate if the underlying factors are different, but unwarranted disparity, how can that be negotiated carefully so that we don't undo what at least we've been aspiring to do on the front end? Anything else kind of to consider in terms of what will the front end actors do? Will sentencing change? May judges adjust sentences to make them longer because they think there'll be a second look afterwards? Is there anything like that that we have to think about? And I always worry about the things we're not thinking about because they haven't happened before. But that's why we have a great panel to get us started on these considerations. So, Judge, if you want to start on
Sure.
this one.
Yes.
Trying to mix it up.
Thank you, Nora. Just briefly on the disparities point, one feature of our system that's insufficiently remarked upon is how many disparities are produced by the prosecutors. It's another way of making the point that Norman and I made earlier. You know, when 8 people are involved in a series of 4 bank robberies, and one of them is doing life because he turned down the deal the rest of them took, and the rest of them have been out for decades, that is an unwarranted disparity, and it's produced by the prosecutors. So one need for this mechanism to check on prosecutors is to eliminate, to do something about the disparities other actors in the system produced. Another issue, and Justice Sotomayor mentioned this in Concepcion recently, one reality is, look, if you're going to have judicial discretion, and we haven't squeezed it all out of the system, obviously, it's going to be exercised in ways that it will differ. You know, when I was on the bench, I thought, you know, my parents died when I was young, so maybe I didn't have sufficient receptivity to arguments about people being sentenced to prison when they had aging parents. You know, I didn't live that. We all bring our baggage to the job. And to the degree you're going to allow individualized sentencing, and we've all agreed that, we're going to still have individualized sentencing and individualized judging. We certainly don't regard judges who some people don't regard judges who routinely sentence at the top of the range as compared to those who routinely sentence at the bottom of the range. You know, most of the folks who cry about disparities, unwarranted disparities, don't think those are unwarranted. They just happen to be within the range, even though those ranges are pretty wide. My point is this, you know, individualized sentencing is a good thing. It went awry back at the time of Marvin Frankel because there was no requirement that you state your reasons. I'm not suggesting that stating reasons and having some appellate review that is not supine the way ours is now. I don't mean for a moment that would squeeze the risk of people acting on explicit or implicit biases completely out of the system, but it would certainly blunt it, right? So the point is, it's not an unwarranted disparity when some judges exercise authority to act upon to exercise second look authority, and some other judges don't. That's what Justice Sotomayor said in Concepcion. It's like not a legitimate objection to say that some people will get the benefit of the discretion that we trust judges with and other people won't. That's inheres in a system in which judges exercise discretion. So it's not, to my mind, those are not, I guess another way to put it, they're not unwarranted disparities. They're the disparities that you agree to bake into your system when you allow judges to judge, because judges are different and they bring their experience to the bench. Is it important to require them to explain what they're doing So the degree to which they might, for reasons, other reasons, might not be warranted disparities, yes. Will there always be that danger that implicit biases influence that judicial discretion? Yes. But that's better than a regime that prescribes a sentence based on the offense of conviction or based on some other routinized mechanical process.
Bruce, you want to go next?
No, but I'll try to follow that. So when I think about disparities, I think that oftentimes we have these conversations where we have this high philosophical treatise that is articulated with grammatical profundity and theory. But in all actuality, where the rubber meets the road, you got too many black, brown, and poor white people who are disproportionately impacted by this criminal legal system, period. One of the reasons why I got involved in legislative advocacy was because there was a righteous indignation that was lit inside of me when I was walking the yard in federal prison. I saw too many black people who look like me. I saw too many brown people who look like my cousins. And I saw too many poor white people who came from my neighborhood who, when they were sentenced, the judges and the prosecutors did not seem to have this degree of empathy that this judge in particular seems to possess. And so I think that when we're talking about disparity, I have a litany of things that I can probably check off that begins with having more judges who come from a public defense background and not necessarily a prosecutorial background. That's number one. The second thing is that even when you're looking at second look in sentencing, I just realized that we're talking about people who are incarcerated, but what about the collateral consequences of folks who are still dealing with legal restrictions in society? According to the American Bar Association, there are more than 46,000 collateral consequences to one felony conviction. That's something that needs to be that's something that needs to have a second look reviewed as well. A third thing that surfaces for me is that when you look at racial and socioeconomic disparities, right? Quite frankly, in the United States of America, if you don't have access to resources and power, influence, and affluence, you are going to find yourself on the higher end of that sentencing guideline. Now, you may occasionally have a judge who says, oh, you know what, I'm going to not sentence you according to what the PSR is recommended and or according to what the government has recommended. But that doesn't happen too often. It just doesn't happen too often. And so it infuriates me. It literally infuriates me when I see people who commit the same offense and they come from different parts of the track. And because this person matriculated through the upper echelons of society, through university, and this individual over here doesn't know the difference between C-spot go and C-spot sit, both of those people with no criminal history are treated different. That just burns me up. It really burns me up. Yes, that's all I have to say.
Maybe just a couple thoughts.
Sorry.
Oh, sorry. No.
Go.
Oh.
Ping pong to the other side and then go ahead.
I'll just add a few points. I think one is, for the reasons that Lewis is articulating, any process that would result in decarceration, particularly of folks who are serving long prison sentences, will help address issues of racial disparity in the criminal justice system, almost by definition, given how disproportionate the system is now. The second point is, I do think that counsel has a really important role to play, and you need to have a system that has counsel playing an important role to ensure, at least to some degree, or to mitigate the possibility of further disparities in the second look context. So if there isn't a right to counsel, then I would be concerned about who ends up making the applications and who gets good results if counsel isn't involved. I've done work with the Office of the Appellate Defender for a long time in New York, and in the New York State parole context, where you don't have a right to counsel, the cases where OAD lawyers have been able to even advise the client on how to present the case to the parole board results in unbelievably higher likelihood of success than cases where no lawyer is involved. And it's both wonderful that they've taken on some of those cases, but it's incredibly dispiriting to think that in most of those cases there's no one involved in helping to present the case. So I think, you know, some of the structural things I would like to think that you'd have to do include having counsel playing a prominent role, including in the context of appealing second look resentencings. I think that would be important too.
Yeah, thanks. And that really dovetails into a point that I want to make. First of all, I do agree that there should be a system that requires reasoning and provides for review. Absolutely, we need to have the right to counsel. I think another way to deal with that we have to anticipate the potential for disparity is by using data, being very conscious. We have to learn all the lessons that we have already learned from mass incarceration so that we track this. I heard Judge Gertner in the last breakout talk about the importance of giving judges real-time feedback on how their own sentencing reflects racial or other potential disparity. But I want to underscore this whole discussion about this concern about disparity by saying very clearly, do not fear discretion. Do not fear judicial discretion. And the reason I say that is I'm probably one of the very few people in this room that practiced criminal defense for 10 years before the guidelines took effect. And I will go back to that system in a heartbeat. I understand there are some bad sentencing judges, but good advocacy can meet that challenge. I had a case out of my home district of New York in the District of Maryland, where I got a judge who everybody said was one of the worst judges in the country. It was a case that involved, talking about the different inputs into the guidelines, it was a marijuana conspiracy. My client was the driver of a truck which had, 1,000 tons. This guy, under the guideline regime, would have faced, under the mandatory regime, even now, I think under the mandatory minimums, could face life or something close to it. And that judge, after a very, I thought, thoughtful presentation that analyzed how this man a young man wound up in that position, he gave him probation. So I'm not afraid of judicial discretion. I understand there will be outliers. That's where the review can take the rough edges off. But I would not be afraid of having some discretion.
Thank you.
I'm trying to figure out where Norm was when I was prosecuted, because I don't know if you were practicing in Connecticut.
Just in the wrong part of the country, I fear. So let me open this up to audience participation now. I figured we'll have a lot of hands. Patty.
Comment real quickly? Yeah. So I think that's such an important point about second look, particularly if it's the sentencing judge that gets to do the resentencing. And I had an experience recently which brought that home in the context of a compassionate release application where, I won't use names of anyone or even too much identifying information, but it was a compassionate release application that I was not particularly optimistic about for a variety of reasons. And it went to a judge who is not known to be a softie and who had imposed a significant sentence, former federal prosecutor. I just wasn't optimistic about it. But what was really interesting, it's someone who hadn't been on the bench for a long time. And when we told the story of the fact that this person who had very serious mental health issues and where the judge had ordered mental health treatment while the person was going to be in BOP custody, it drove this judge got very mad, clearly, that the person hadn't gotten the treatment that the judge had ordered. And I think the judge had worked on the assumption if a judge orders it, it's going to happen. And of course, we all know, having done this for a long time, it often doesn't happen. And the judge reduced the sentence. It wasn't a huge reduction, but it meant a lot to this person. It was like, an 18-month reduction in sentencing. That feedback loop for judges, particularly judges who haven't been at it for a long time and had, a lot of opportunity to see what happens when someone's in prison, I think is really helpful for judges as they move forward and think about sentencing issues. To me, it's a huge bonus of having it go back to the same judge.
When we passed the First Step Act, when I say we, I work for an organization called Cut 50, and we led the effort in order to be able to pass the First Step Act. Since then, I have gone into many United States federal district courtrooms to advocate on behalf of people who were either there to have a second look under First Step Act and or compassionate release. And one situation in particular rises to what your notion is. There was a judge in the District of Pennsylvania who has sentenced two friends of mine. Both were first-time, less serious offenders. One was actually playing D1 basketball. The original sentencing judge said that because there were co-defendants in the case who had committed violence, but that by extension, these two individuals had to have some knowledge of that violence that was committed. He would never, and both, keep in mind, they were two brothers. One was serving life sentence, one was serving a triple life sentence running concurrent. He said his recommendation was that no one in the case should have been released. That judge just happened to retire probably about 6 months prior to us passing the First Step Act. By the time the two brothers get back in court in 2019, they're with a different judge. The prosecutor, the government in the case, argues, hey, the previous sentencing judge said that these individuals should not be released. Thereby, current judge, you shouldn't release these individuals. And the current judge literally made a resentencing decision based off of his own conscience. And both of those brothers were released within 6 weeks of each other after serving 20 years in federal prison. And so the point that I'm making is that sometimes there are some people, it's just human nature. You get emotionally tied to something. You just get tethered to this issue. And once you dig in on a position, you are not going to move from that position. So I do think that there are situations and circumstances, especially when you have a judge who's going to say, hey, who's going to be obstinate about this individual not having another opportunity at freedom. I do think that there are circumstances and situations where there should be someone else to take those factors into consideration.
Nora, can I take a moment to add to Lewis's comment? I can imagine a world, David, in which if, for example, the way to respond to your concern is the case goes back in the wheel, then you're going to have clients whose cases started out with judges who are empathetic and get wheeled out to a judge that you're feeling terrible about. So that I'm not sure but let me suggest that this is one area in which the absence of any meaningful appellate review is problematic. You know, there's no such thing. It's not literally, but virtually, substantive review of sentencing decisions, whether they're sentence reduction motions or sentencings themselves, in our circuit doesn't really exist, And I think you've identified a circumstance in which, in a world where judges had to explain themselves and the explanation was insufficient, there would actually be some abuse of discretion review that had some traction to it instead of a rubber stamp. It might rein in excessively lenient judges as well, but still, I think that's a price worth paying. One thing I'll mention apropos of Sean's comment is there was, this right to counsel is so important, and we've done so many cases in which a sentence reduction motion was made pro se and just denied perfunctorily, and then we renew it 6 months later in a counseled motion, and we get the relief. And there was one district that will remain unnamed in which the judges decided the defenders were not authorized. These are not collateral attacks. These are motions to reduce the sentence under a statute. And the judges decided, no. The appropriations for the defenders can't cover this. And we kind of shamed that district out of it. But it's a very important feature of this what we're talking about, to ensure that a right to counsel at the instant level, whether it's a judge or elsewhere, and for some review is present, because that makes all the difference in the world.
Just one point about resources. I mean, to state the obvious, it's very expensive to incarcerate people.
Yeah.
And so, if on some meaningful scale you're reducing the prison population, it frees up a lot of money to pay additional money to the defenders or to CJA to represent folks in these cases, and frankly, to reallocate BOP monies for like some programming, for example. But it's we shouldn't lose sight of that. I know the better arguments are around dignity and humanity and everything else, but there's also just a cost-benefit public policy question about how we're spending money.
It's tough to get BOP to write that check, though. As John mentioned earlier, there's no fewer prisons now. But if only the cost savings associated with alternatives to incarceration produced a check written from BOP to us, it might be a better. Just doesn't work that way, unfortunately.
And I realize that many of you have much deeper experience, but I actually, when I was a first-year law student, did a parole hearing because our clinic did parole hearings. And it was an incredible experience. It was a great learning tool. And as I learned, we did a much better job than the private lawyers who were retained at high cost, who literally, I will never forget this, were sitting outside the hearing room for the first time, reading a file, meeting their client, while the clinic had done all the background research, had talked to scores of people, was really well prepared to argue this, had met with the client. Of course, all of this for no cost to the client. So I could not second the right to counsel more, even kind of from that experience. I've Nancy, Adam, then many more people. So from the panelists.
I think there's a sliding scale between the increased availability and the ability of the judicial system to do it. But I certainly agree with an idea that if it's going to be readily available to everyone, because parole was a second look at every single sentence, not sure that's administrable unless there's fundamental change in resource allocation in the judiciary, which I'd be in favor of. But if you don't do that, you might need to do a system that's not judicial, just so you could administer the system. I think those are the two competing interests.
First, I think all the points that were raised by those of you who just spoke are all really valid points. To Adam, I am not concerned about sentence inflation. I'm not concerned about it. First of all, if you have a system in which it does go back to the judge is going to have to make a judgment. The whole concept of second look, it's implicit in it, is that there's evidence that the person has changed, which we know everyone is capable of. Well, whether they do it or not is a different story. I personally think that there's a good chance. David's point about the judge who's dug in because of the nature of the crime is a factor. But I think most people, most fair-minded judges are going to look and see, hey, this person has done really well, and they're not the same person that they were. So not really concerned about that, particularly with the longer sentences.
Right. Sean, Lewis.
No, look, I agree with all the comments that were made. I have the same instinct. If it's going back to the same judge, I wouldn't worry about the inflation point. I guess maybe that could become a factor if there were an agency model for it. I personally think about these resentencings, though, also as like hearings where you might call witnesses and family members and maybe even a corrections officer who has firsthand experience with the person. And that sort of lends itself to a court setting from just the way I think about it. But, Lord knows larger reform would be wonderful in this area.
Well, aside from nominating the judge as the next United States Attorney General, to make sure that our at the very least on the federal system, we're super transformative. I go back to the notion about just people changing, giving human beings the dexterity, just create an allowance for change. And when that person presents back before the court, and if he or she has done the smart work in order to be able to change, that should be taken into very strong consideration.
Let me thank all of you here on the panel and our audience for a great conversation.